This is Barry Zellma speaking for Claim School Incorporated's blog, Zellma on Insurance. Today we're talking about what happens when there is an untrue statement in an application for insurance, only to find that it voids the policy, and why misrepresentation or concealment of a material fact will support a claim for rescission. It simply means don't lie to your insurance company if you really want to have insurance that you're buying. In a case entitled Imani Page versus Progressive Marathon Insurance Company, the Court of Appeals of Michigan on September 22, 2025, because the defendant successfully established fraud in the procurement and requested rescission, the Court of Appeals concluded that the defendant was entitled to rescind the policy and declare it void ab initio or from its inception. Plaintiff applied for an insurance policy with the defendant, indicating that the primary use of her SUV would be personal purposes. Plaintiff misrepresented that she would not use the SUV for food delivery, but records show she was compensated for delivering food. Plaintiff's SUV was involved in an accident on August 6, 2021, but she was not performing any task for the delivery service at the time. Defendant, regardless, rescinded the policy due to the alleged material misrepresentation of fact. The Court of Appeal, analyzing the case, first dealt with common law fraud. The elements of common law fraud, of course, include a false statement, knowingly false, intentionality, reliance by the defendant, and injury to the defendant. A misrepresentation is material if it substantially increases the chances of loss insured against, leading to a rejection of the risk or an increased premium. Defendant claimed it was entitled to rescind the policy and declare it void ab initio due to the plaintiff's fraud in the procurement of the policy. Plaintiff argued that she had not made any misrepresentations to the defendant because she was not asked about the use of her SUV, even though she answered the question that she only used it for pleasure use. The Court of Appeals noted that the insurer to rescind must prove the first 5 elements for establishing fraud or fraudulent misrepresentation, which include that the insurer proved that the insured makes false representations, that the insured knew the statement was false, and made it with the intent that it be relied upon by the insurer, who in fact did rely on the false statement. Defendant argued that it was entitled to rescind the policy of insurance because plaintiff's declaration that she would not receive compensation to use the SUV to deliver food was a material misrepresentation upon which the defendant relied. Specifically, defendant issued an insurance policy to plaintiff for which it charged 33% less than it would have if plaintiff had not made the false declaration. The generally accepted test for determining the materiality of a fact or matter as to which a representation is made to the insurer by an applicant for insurance is to be found in the answer to the question whether reasonably careful and intelligent underwriters would have regarded the fact or matter communicated at the time of effecting the insurance as substantially increasing the chances of loss insured against so as to bring about a rejection of the risk or charging of an increased premium. Because plaintiff was already driving for the food delivery service at the time of her application, her answer to the question about food delivery established the elements of common law fraud, and accordingly the Court of Appeals concluded that a reasonably careful and intelligent underwriter would have regarded the anticipated use of the SUV for paid food delivery services substantially increasing the chances of loss insured against so as to bring about the charging of an increased premium. The Court of Appeals concluded that the trial court erred in denying the defendant insurance company's motion for summary disposition, as there was no genuine issue of material fact. And because defendant in the present case has established plaintiff's fraud in the procurement such they were not dealing with the claim of an innocent third party and requested rescission, it was entitled to rescind the policy and declare it void ab initio from its inception. In my opinion, rescission is a remedy as ancient as the ecclesiastical courts of ancient England, where priests acting as judges were charged with ruling only about fairness rather than making money judgments. One of the remedies available to the ecclesiastical courts was the remedy of rescission, where a contract made by fraud could be placed back in the situation the parties were in before the contract was made. In modern courts, practice courts act as both law courts and equity courts. So in all fairness, Ms. Page, according to the Court of Appeal, acting as a court of equity, gave her back the premium she paid, and the insurer was given back the policy as if it was never issued. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL selma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 150 blog postings. If you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a small fee subscribing to my Substack publications. And please tell your friends and colleagues about the blog and these videos. They're free so that they too can subscribe. Thank you for your attention.